Hello everyone. Today we are going to discuss topic the topic salary, which is given under section from section 15 to 17 in the Income Tax Act 1961. So let us start with section 15, which says so the following income shall be chargeable to income tax under the head salary. So clause A of 15 section 15 says any salary due from an employer or a former employer to an SSC in the previous year, whether paid or not. It means any salary which is due from an employer or a former employer to an SSC. It means suppose let us I would like to explain it with the help of an example. The example is, suppose X is an employee working in a company A, and that employee has worked for a month. Like suppose that person has worked in the month of February, right? It means that person worked for the month and that person has not got the salary yet. So it means an employee is supposed to work for a month, and after that that person becomes entitled for the salary. Whether that salary is paid or not paid, that salary will be taxable in the hand of that employee. Okay, now let us look at clause B of section 15. Any salary paid or allowed to him in the previous year by or on behalf of an employer or a former employer, though not due or before it became due to him, right? It means any salary paid or allowed to him, which is either paid or allowed to him in the previous year. So now I would like to explain what is previous year. Previous year is the year in which an employee earns his salary. That salary, it means as we know, the financial year that starts from 1st of April till 31st of March. This is the financial year. So in this financial year, whatever salary which is earned by an employee, this will be the previous year. And in the next year, where the person is supposed to pay the tax, that will be the assessment year. So for example, from 1st of April 2019 till 31st of March 2020, this is the previous year, and the tax and the assessment year for the year 1920, the assessment year will be 2021, right? So assessment year is the year in which an employee, the SSC means the taxpayer who pays tax, right? So previous year is the year in which an employee, the person, earns salary, and assessment year is the year in which the person is going to pay tax, and SSC is the taxpayer, right? It means any salary which is paid or allowed to him in the previous year, which is either paid or allowed to him in the previous year, or on behalf of an employer, which is on behalf of on behalf of an employer or a former employer, though not due or before it became, which is though not due or before it became due to him, right? Now any areas of salary paid or allowed to him in the previous year by or on behalf of an employer or a former employer, if not charged to income tax for any earlier previous year. It means any areas of salary, right? Any salary which which a person is supposed to get, but he has not got it, right? Which is he's supposed to get in the later time. So it means any areas of salary which an employee is supposed to get, and for that he is not accountable in the previous year. It means there has been no tax liability for that areas of salary. Suppose, as I told you, which is due, as in the clause A, it says about it talks about whether paid or not, right? It means that any salary which is paid or not, that becomes taxable. Here areas of salary means which the salary which the employee was supposed to get but he has not got it, and for that salary the employee has not been taxed, right? So any salary for which is areas in salary for which he has not been taxed, number one, right? For which he has not been taxed, right? For which he has not been taxed, for that thing will be included in the salary. Suppose for that areas of salary, if the person has already been taxed in the previous year, there has been a tax liability in the previous year in which he has already earned and he has already paid the tax. So that areas of for that areas of salary, suppose that areas of salary for which a person has already paid tax in the later year, suppose okay, for example, in the year 1920 a person has already been taxed for the areas of salary, right? So and in the later year in 2021, when the employee gets that salary in actual terms, gets that salary, then the actual receiving of that amount will not is not going to make him taxable again. So it means he is not supposed to be taxed again. If there has if the employee has already been taxed in the previous year, then that will not be taken as areas of salary, right? So this is what it means. It means if not, as it is saying, if not charged to income tax for an earlier previous year, so that employee should not have been had not been taxed in the previous year, right? Now let's move ahead. Here in this section we can see there are two explanations. The explanation one, which says, for the removal of doubt, it is hereby declared that where any salary paid in advance is included in the total income of any person for previous year, it shall not be included again in the total income of the person when the salary becomes due, right? So it means here, when any salary which is paid in advance and it is included in the total income of person for any previous year, it means suppose for let us take an example. Suppose a person is working in a company A, and that employee has already got the salary for the month of, that is April, May, June, right? April, May, June. So April, May, June becomes another financial year, another previous year, and because that April, May, June, suppose a person is working in a company in a company, and the month in which the employee has got the salary, that is the month of February 2019. So February 2019, it is already a previous year 1920, and now April, May, June. This April, May, June will be taken as another previous year, that will be previous year 2021, right? So for the 2021, for this period, the employee has already been paid, has already got the advance of these 3 months in the year in the month of February 2019 already. So it means a person who has got this salary in the year 2019, February 2019, he will not be taxed again, right? Because he has already got that money beforehand. So that will be taken as a taxable salary in the previous year 1920, not in the year 2021. Okay. So an explanation 2 says, any salary, bonus, commission on remuneration by whatever name called, due to or received by a partner of a firm from the firm shall not be regarded as salary for the purpose of this section. It means any partner who is working in some firm, partnership firm, whether he is receiving any salary, bonus, commission or remuneration by whatever name called, that will not be taken as salary, right? Now let us move to section 17. The section 17 talks about what are the other things which are taken together to make it a salary. So it says, for the purpose of section 15 and 16 and of this section, salary includes wages, any annuity or pension, any gratuity, any fees, commission, perquisite, or profits in lieu or in addition to salary or wages, any advance of salary. Right? It means these are the forms which are included into salary, and any of the form will be called salary, right? If that is wages, that will also be called salary. Any annuity or pension, even that will be called salary, right? If suppose any person was retired, after retirement, if that person is getting pension, so even that will be considered as salary, right? Any gratuity after retirement, after the leaving company, for working for the 5, 7, 8 years, like whatever as per the norms of the company, if any person is receiving any gratuity, even that will be called salary. That will be included into salary. Any fees, commission, perquisites, or profits in lieu of or in addition to salary, even that will be taken as salary, right, or any advance of salary. Okay, now let us move ahead. And after that, 17 clause 2 talks about perquisites. What do we mean by perquisites? The perquisite means the value of rent-free accommodation provided to the SSC by his employer. It means if there is any employer who is providing any rent-free accommodation to his employee, it means the value of rent-free. It means that whatever the value of that rent-free accommodation is, that will be added to the salary of that, because that's a benefit. Had that person been living at some other place, so that definitely that person would have been paying that rent. So here, just because that rent the company is paying on his behalf, the company is already has provided that rent-free accommodation to his employees, so that will be taken as perquisites, right? And the value of any concession in the matter of rent respecting any accommodation provided to the SSC by his employer. It means any value of concession in the matter of rent respecting any accommodation, right, provided to the SSC. Any concession in the rent, be it 2,000, 4,000, whatever concession, right? So that will be taken as perquisites. And after this, there are some of the examples of the perquisites. Following perquisites are taxable in the hands of an employee. That is rent-free accommodation, accommodation at concessional rate, notified benefits. Rent-free accommodation we have already discussed. Accommodation at concessional rate. Suppose concessional rate, whatever concession, right? A market value of any accommodation, suppose that is 10,000 rupees, right? And that person is getting at a lesser price, right? He's got a concession of 5,000, 6,000 rupees. He's just supposed to pay 4,000 rupees, 5,000 rupees. So whatever money he's saving, that thing will be taken as perquisites. Notified benefits and amenities, if any, there are some benefits which the company is providing to the employee, so even that will be that has some value, so that will be taken as perquisites. Employee's obligation met by the employer, if there are some of the obligations upon the employer, and that is being paid by the employer, so that thing will be taken thing will be again taken as perquisites. Amount payable by employer to effect an insurance on the life of the employee. If the company is paying on the insurance to effect an insurance on the life of the employee, even that will be taken as perquisite, right? Let us move ahead. Now, so there are some of the tax-free perquisites for all the employees. There are some of the tax-free perquisites, right, which are tax-free. Like those things will not be taxable, like food beverages provided to the employees. If the company is providing some kind of food beverages, so that thing will not be that thing will not be considered, that will not be taxable perquisites. That will be tax free, right? There will be no tax for it. Like this is the same way, if the company is providing loans to the employees, even that will be tax free. If the company is providing, there's a difference. Rent free accommodation or conveyance facility. Rent free accommodation for the High Court, Supreme Court judges, member of parliaments, and the employees of the parliaments, all the government employees, the parliament and all, right? So they any rent-free accommodation provided to them, right, that is tax-free, right? So this is the exception here. So this is the exception which says rent-free houses, it is only for the High Court, Supreme Court judges, the government employees of the parliament, right? And after the perquisites provided outside India, so suppose the central government is providing any facilities, any perquisites outside to its government employees, even that will be tax-free. Accommodation in remote area, in any remote area, if that accommodation is being provided, even that will be tax-free. Education facility to children of the employees, if the company is providing any education facility to the employees, so even that will be tax-free. Computer and laptops, if there are computer and laptops, even that will be tax-free. Tax-free perquisites, right? If the company is providing perquisites, if the company is providing laptops, computer laptops, so that will be tax-free. Leave travel concession, if the company is providing some leave travel concession, so that will, because leave travel, that will be tax-free also, right? So there's even that will be tax-free. Tax paid by the employer on non-monetary perquisites, if the company is paying some tax, if the employer is paying some tax on non-monetary perquisites, the perquisite which have no value, non-monetary perquisite, which has no value, right? Non-monetary, this itself It is very clear non-monetary. And after that, first aid medical facility, if the first aid medical facility that is being provided by the company, so even that will be tax free, there will be no tax. Medical reimbursement, so if there is some medical, the employee has taken some has spent some money on his medical expenses, if that is being reimbursed, so that will not be taxable. Recreational facilities, if the company is providing some kind of recreational facilities, like some kind of entertainment facilities and all within the company itself and all, so even that will be tax free, there will be no tax for the same, right? And after that, training of employees, if the company is providing some training to the employees, even that will be tax free. There is no I mean, that will tax free perquisite, so I mean, there will be, that will not be taken as a taxable perquisite. Okay, use of health clubs, as I said, health clubs, sports and similar facility, health clubs and sports facility, whatever the facilities are being provided by the company, even that will be tax free perquisites. Okay, and after that, expenses on telephone, even that will be tax free. Employer's contribution to superannuation fund, if the employer is providing some contribution to the superannuation fund, because of an employee is supposed to work for a certain age, so and there's a clause that if a person is working for 60 years, after that he will get some amount after that, so that will be not that amount, the contribution, talking about the contribution, that will be tax free. And other perquisites, there are many lists, so these are some of the few perquisites which I have discussed. And after that, it is 7. Now let us look at section 17 clause 3. It talks about profits in lieu of salary. So it means there are some of the profits which you get in the place of salary, so even that will be taxable, so that will be considered as salary. The amount of any compensation due to or received by an SSC from his employer or former employer or employer at or in connection with the termination of his employment or the modification of the terms and conditions relating thereto. It means any amount of compensation which is due or received by an SSC from his employer, either employer or his former employer, or in connection with the termination of his employment. I mean, where his services have been terminated, where his job has been terminated, he has been expelled from his job. So for that, if he or in the modification of the terms, for that, if the employee is getting some kind of compensation, so that will be taken as, so that will be called profits in lieu of salary, right? So there are some of the examples what are called profits in lieu of salaries. Compensation on termination of employment, if there is some compensation which is being provided by the employer on the termination, right? So even that will be profits in lieu of salary. Payment from unrecognized provident fund or unrecognized superannuation fund. Payments from unrecognized provident funds. So the catch is unrecognized provident funds, not the recognized provident funds. If there is some payment which a person is receiving from unrecognized, which are not recognized provident funds, or unrecognized superannuation fund, if any superannuation fund scheme which is unrecognized, so for that, any out of that, if the person is receiving any payment, so that will be profits in lieu of salary, right? After that, payment under Keyman insurance policy. It's a Keyman insurance policy. It's a specific policy which is called Keyman insurance policy. If there is any payment from that, if the employee is receiving any payment from that, so even that will be considered profits in lieu of salary, right? After that, any amount due or received before joining or after cessation of employment. It means if the employee is getting any amount before joining or after cessation, means after the completion of the job, right? Completion of the employment. So that will be taken as profits in lieu of salary, right? So now let's move ahead. After that, we can see we have deductions from salaries. It means section 16 talks about the income chargeable under the head salaries shall be computed after making the following deductions, namely, it means before calculating salary, there will be some deductions. So these deductions are deduction in respect of any allowance in nature of an entertainment allowance. It means any deduction in the nature of an entertainment allowance specifically granted by an employer to the SSC. Granted by an employer, which is being granted by an employer to SSC who is in receipt of a salary from the government. It means who in receipt from the salary from the government. It means government is paying him. So the catch is salary from the government. If the person is getting any salary from the government, right, and that employee, right, so if that employee is also receiving some kind of entertainment allowance, right, so there will be deduction in respect of any allowance in the nature of entertainment allowance, right, a sum equal to 1/5 of salary of 5,000, whichever is less. It means, suppose his salary is 50,000, so 1/5 of 50,000 will be 10,000 or 5,000. So out of this 10,000, 5,000 out of 10,000 or 5,000, which is less? 5,000 rupees is less. So there will be deduction of 5,000, right? Now let us move ahead. Now look at the section 16 clause 3. It is a deduction from any sum paid by SSC on account of a tax. It means there will be, if there is any deduction which is paid by the SSC on account of a tax on employment within the meaning of Article 276 clause 2 of the Constitution of India. It means if there is any deduction which is paid by the SSC, which SSC has already paid on account of a tax, there is a tax liability under tax on employment within, under, there is a tax liability which is coming under Article 276 clause 2 of the Constitution of India. So even that will be deducted. It means these are the two deductions which will be while calculating taxable income. These deductions will be, after making these deductions, then we will take out the taxable salary, right? Now after this, I would like to discuss two important cases, and after these two cases, the topic salary will be completed. Okay, so now the case is CIT means Commissioner of Income Tax versus LW Russell AIR 1956 SC 49. In this, the main crux of the case is, the main point of the case is, the one cannot be said to allow a perquisites to an employee if the employee has no right to the same. It cannot apply to contingent payments which the employee has no right till the contingency occurs. In this case, what happens is, this case talks about a particular contingency. In this, a company was paying a premium towards superannuation fund, which was 3,334 rupees towards the premium for the superannuation fund. So as we know that if there is any contribution by the employer towards the superannuation fund, so that will be taxable. And so in this, Commissioner of Income Tax had just made it taxable, but there was a catch. The catch in the superannuation fund scheme was that an employee, in order to be entitled for that superannuation scheme, right, superannuation scheme, was supposed to complete an age. So here in order to be eligible for that superannuation fund, he was supposed to complete that age, suppose 60 years of age. And if the employee is retiring, is just leaving that job before that superannuation that particular age, so then that employee will not be entitled for the entitled for that sum. So it means he will himself forfeit. He will himself just lose that superannuation fund money. So here the thing is, in most of the company, it happens that in order to retain the employees for a long time, so these kind of schemes are made. So in this case also, it was held by the appellate court that this 3,334 rupees is not taxable as perquisites in the hand of taxable as perquisites and will not be included. Reason because the employee had already left the job before the completion of that specific age. So in this case, what was held that in the I would like to just read some of the important points. In the present case, according to the rules framed under the scheme, till the respondent reached the age of superannuation, the amounts vested in the trustees and the beneficiary under the trust could be ascertained only on the happening of one or other of the contingencies provided for under the trust deed. So under this trust deed, there were some conditions. It means on the fulfillment of those conditions, then only the employee was entitled for that superannuation fund, right? So on the happening of one contingency, the employer was to become the beneficiary on the happening of another contingency. It means if on the happening of that contingency only, then only the employee was employee would get the benefit of that superannuation fund, right? So in this case, if the suppose if that contingency, if that condition is not fulfilled, then in that case the employer will get the benefit of that, because that all the money will go back to the employer, employee will not get it. And in order to get the benefit of that scheme, employee was supposed to work till a particular age. So just because the employee had not worked till that particular age, he was not entitled for this 3,334 rupees. It means this premium was not taxable in his hand, right? So specifically, the court has held that there is no interest in the sum contributed by the employer. It means there is no interest which the employee has got in this, which the employee has got in this amount, 3,334 rupees, under the scheme vested in the employee, as it was only a contingent interest depending on the reaching of the age of superannuation by the respondent. So it is saying it was only a contingent interest depending upon the reaching of age of superannuation. It means the employee was supposed to reach that particular age. Just because the employee has not reached that particular age, so just because of it, that 3,334 rupees, the premium which was paid by the company, the employer, was not taxable in the hands of the employee, right? So therefore the court held that it was not a it was not a perquisite allowed to him by the employer within the meaning of section 7 clause 1 of the Income Tax Act, right? So this way it was held that it was because the condition of the scheme was not fulfilled, so just because of that particular premium was not taxable in the hands of the employee, right? Now after that, the last important case. After this, we will complete the topic salary. See, the second important case is Ram Prasad versus CIT. CIT means Commissioner of Income Tax, 1972, 86 ITR 122 SC. In this case, the main important crux is whether a director is a servant or agent may be determined by the articles of association of a company, or the agreement if under such contractual relation between the director and the company has been brought about, right? Between the director and the company has been brought about. In this case, the director was held an employee of the company, and therefore his remuneration was assessable as salary. So in this case, what happens is that in the main point of contention between the parties was that whether the director is a agent or servant of the company. So in order to see this particular point, court looked into the articles of association. So it depends upon the facts and circumstances of every case. In this case, what happens is in order to decide whether a director is agent or servant, it depends upon the control of the board of directors, and a director will be an agent of the company when he is working under the directions under the guidance of the board of directors, and along with that he is independent also, right? So that time he will be agent. And in order to be called servant of the company, for that the board of directors are supposed to have a proper control upon upon the director. Board of directors, they just gave him all the directions, and the terms of the articles of association is such which because of which he becomes totally under the control of the company, right? So in this case, it was held that in the present case, what court observes, and it is the observation by the court, in the present case, a perusal of the articles and terms of the conditions of the agreement definitely indicated that the powers of the SSC had to be exercised within the terms and limitations prescribed in the articles and subject to the control and supervision of the directors, which was indicative of his being employed as a servant of the company. It means the terms, right? The terms in the terms and limitation prescribed in the articles was such that because of which there was the director was subject to the control and supervision of the directors, and was indicative of, and this was indicating that he was the servant of the company, right? So here the main issue was that because just because this Mr. Ram Prasad, Mr. Ram Prasad was he was director in this company, so he was getting a profit. He was supposed to get 10% profit of the company, which was coming around 53,913 rupees. So it was a revenue receipt. What is capital receipt? Capital receipt, which happens like after which does not happen regularly. Revenue receipt is which happens regularly. Like suppose a company is going to earn money. Company earns profit yearly. Company every year earns profit. So just because Mr. Ram Prasad, he was the director of the company, he was a director in the company. So being director in the company, he was getting 10% profit. So in this case, the court held that this 53,913 rupees was a revenue receipt and had accrued to the SSC in the year of account and payable to him as salary, and thus was taxable. So it was salary. The contention of Mr. Ram Prasad was that this amount which he has received, he has already given up. He did not after receiving this money, he did not just he simply returned the money to the company. But still, as we know that it was due. It is let me explain. What happens is, suppose X is a person who has got money from the company being a salary. After that, even if that person has returned that salary to the company, so still that person will be taxable for that salary. So that was his will. So out of his own free will, he had just returned that money. So still the tax authorities are going to tax him, right? And the court said the voluntary foregoing of the amount was mere application of income. It means voluntarily he had just foregone that money. He had just simply returned that money to the company. So here, in order to decide whether a director is agent or servant of the company, we need to look into the articles of association, right? So in this case, it was held that the director is not the agent of the company. He is not the agent of the company. He is the servant of the company, being director. And just in order to find whether he's agent or servant, the court had looked into this terms and conditions terms and conditions of the articles of associations. So before deciding whether a director is servant or agent, it depends upon the facts and circumstances of every case. So ultimately, it was held that the director was servant, and his 53,913 rupees, which he had got from the company, which he had got from the company, that was his salary, right? So with this, so we have already I've already just explained both the cases, CIT versus LW Russell, and in this case, it was held that in order to just that 3,334 rupees before to be entitled, before that thing to be taxable in the hands of the employee, he was supposed to complete certain age. And in this case, it was held that he was director after looking into the terms of the articles of association. It was held that because he was under the control, under the supervision of the board of directors, and there was complete control upon the director. So it was held that he was servant, and that his 53,913 rupees was taxable in his hand as salary. So with this, we have completed this topic, salary, and thank you very much.